Good evening, everyone. And for those attending remotely, good evening from London to everyone. And just to welcome you all on behalf of the Shipping Law Centre to this seminar to discuss the case of the Tai Prize. I'm not going to introduce the speakers. I am going to introduce the chairman, Stephen Males, who I've known for many years, originally in 3 Essex Court, I believe, which then became the current 20 Essex Street. About 10 years ago, he went on the bench and I think has been a Court of Appeal judge now for 3 years. That's right, for 3 years. So without more, I should leave to Stephen to introduce the talk and the speakers.
Well, thank you, Graham. Can I add my welcome both to those who are here in the room and also to those attending online. I'm feeling rather nervous. It may not be a terribly comfortable experience to have one of my decisions dissected by such eminent speakers as we have tonight. In general, it's a very good rule that judges don't speak publicly about their judgments, and I don't really propose to break that rule. We're here tonight to look at a case called the Tai Prize. It's a case where the arbitrator decided in favour of the charterer, and the commercial court on appeal then decided in favour of the owner. There was then an appeal to the Court of Appeal. Sometimes, actually, the most interesting cases we get in the Court of Appeal, at least from my point of view, are shipping cases where the arbitrator goes one way and the commercial court judge goes another. That's quite a rarity, of course, because appeals under Section 69 don't get through the process very often and come up to the Court of Appeal even less. But as it happens, I'm giving judgment tomorrow in another case where the arbitrator went one way and the commercial judge went the other way. And I'm due to sit on yet another such case next week. So it's quite a purple patch for me at the moment. And it shows that shipping law is still capable of throwing up some fascinating questions. Long may that continue. And long may the London Shipping Law Centre continue to hold these seminars to discuss them. The Tai Prize raised a rather tricky and maybe quite common scenario, which our speakers will explain. In a nutshell, on discharge, the cargo was found to be in damaged condition. The damage was caused, as the arbitrator found, by the condition on shipment, but that damage was not apparent to the master, and there was nothing he should have done which would have enabled him to find out about it, so he issued a clean bill of lading. In those circumstances, the owners ought to have been in the clear. They'd have a defence of inherent vice under the Hague Rules to the receiver's cargo claims. But it turned out not to be so simple as that. The owner did his best to defend the claim, but nevertheless was held liable in the local court. He then looked to the charterer for an indemnity, saying, well, it's the condition of the cargo you put on board that caused all this trouble. You ought to indemnify me. You might have some sympathy for that point of view, but although the owner succeeded before the arbitrator, I'm afraid he failed when he got to the commercial court and to us. Now, I would like to think that that was for good legal reasons, but I can certainly understand that some people, particularly ship owner interests, may think that that result does just not feel right. And from a commercial viewpoint, I have some sympathy for the arbitrator's conclusion. Well, here to explain the case and its implications are the two counsel who argued it. We have James Leabeater to my right, then QC, now KC, who represented the owner, Alex Wright to my left, then a junior, but now KC represented the charterer. Neither of them needs much from me by way of introduction. Both are enormously experienced shipping lawyers and fine advocates. You've got their CVs, which you will see certainly make good what I've just said. Anyone who's had the misfortune to read my judgments will know that I do not dish out compliments lightly. But I looked again at the judgment and I see that I paid tribute to both of them, in this case, for the high quality of their written and oral submissions. And I'm sure that they'll both be on top form tonight. Alex will go first to outline briefly what the case was about, putting slightly more flesh on the bones, which I've just indicated. James will then explain no doubt what a disaster the Court of Appeal decision was. And Alex will then, I hope, ride to the rescue. I'm counting on him and hoping, even if he doesn't manage to persuade you that the case was rightly decided, that perhaps it was not obviously wrong. As you know, in the world of arbitration, that's all any of us can really hope for. I hope we'll then have time for Q&A. Please, if you're watching online, do submit questions and also be thinking about that in the room. For my part, I'm particularly interested in contributions from the floor, which can tell us more about the practical implications of the decision and indeed what, if they don't like the results, parties can do about it. Anyway, without more ado, I'll hand over to Alex.
Thank you very much indeed, Sir Stephen, for that very generous introduction. And thank you everyone, both in the room and listening online, to participating in this seminar. As Sir Stephen has outlined, I will develop a bit more in terms of the factual background and also touch upon a couple of arguments that were advanced before the arbitrator, which were unsuccessful and not pursued on appeal, because those offer alternative ways that the case could have been, and it does indeed was put, but didn't bear fruit either. I'll then hand over to James to say what he would have said if the case had got to the Supreme Court, and then back to me. So in terms of the general factual background, the facts of the case are reasonably common to those of us who work in this field. It was a voyage charter for the carriage of a cargo of soybeans from Brazil to the People's Republic of China. The cargo was just over 63,000 metric tons soybeans in bulk. It was loaded in July 2012 from a silo via mechanical hoppers at the terminal at the load port in Santos. The shippers, in the ordinary way, drafted the bill of lading for presentation to the master for his signature. The bill was on the congen bill form. In fact, the charter party contemplated bills on the North American grain bill form, but nothing turned on that. But as many in this room will know, the congen bill printed text has the words "shipped at the port of loading in apparent good order and condition on board the vessel. Weight, measure, quality, quantity, condition, contents, and value unknown." And then into the box headed shipper's description appeared the typed words "clean on board." So this was, to any reader of the bill, a clean bill. The master executed the bill without reservation, as required by Clause 6, in circumstances where he was not aware of any defects in the cargo's order or condition. In fact, however, the cargo was damaged prior to loading, and so at outturn, when the cargo was discharged, the receivers brought a claim against the head owners in China, with claims then passed down the chain. As Sir Stephen has outlined, the head owners were found liable, both at first instance and on appeal, and ended up paying the receivers a little more than $1 million. Significantly, their claim against the disponent owners, who were the claimant in the arbitration, and James's clients, was brought under the interclub agreement as incorporated into the head time charter. It was not a claim under any implied indemnity. It was a claim for a 50% contribution under Clause 8D that arose only as a result of the incorporation of the ICA. That was then settled by the time charterers, effectively at full value of the 50%, and a claim presented against my clients, the voyage charterers. And of course, the distinction between the intermediate charterers hiring in on a time charter basis and then chartering out on a voyage charter basis was one of the reasons why we said that they were effectively in the position of piggy in the middle, and why they could not commercially complain that they had to pick up some of the liability. In terms of further specific findings by the tribunal that informed the legal arguments on appeal and the tribunal's own decision, as I've indicated, the cargo was not in actual good ordering condition on loading. There was a live debate, which James will explain in further detail, as to whether or not it was in apparent good order and condition. And as Sir Stephen said in his judgment, that raises the question as to apparency to whom. The damage to the cargo which occurred prior to loading was either reasonably observable or ought to have been to the shippers. And so the shippers were deemed to have known what is slightly cumbersomely known as the actual apparent condition of the cargo, albeit that there was no finding of actual knowledge on the part of the shipper. But the damage was not reasonably observable by the master, crew, or any of the agents of the owners at and during loading. So if apparency was to be judged from the perspective of the master, so far as he was concerned, or a reasonably observant master in his position, the cargo was indeed in apparent good order and condition. And then the final finding, which is something of a standalone but key to the owner's argument, was that it was held that the shippers were the charterer's agents for the purposes of drafting the bill. Before James gets on to what arguments he succeeded on and then went up, first of all, to the commercial court and then to the Court of Appeal, two routes that were pursued before the arbitrator but finished there, and one route that wasn't taken at all, but which might have arisen on different facts. The first argument that were made by the owners for the arbitrator was one based on the proper construction of clause 35. It's an exceptions clause in essentially standard form. Neither the vessel nor the master or owners shall be held liable for any loss of or damage or delay to the cargo for causes accepted by US COGSA, the Hague Rules. And the argument that was put was that that was a warranty or indemnity that if the owners became liable to cargo interests in circumstances where they ought not to have been, pursuant to clause 35, then either as a matter of construction or implication, they were entitled to recover such liability from the voyage charterers. The arbitrator had little difficulty, if I may say so, in rejecting that argument. An exceptions clause is an exceptions clause. It does not provide an indemnity, and see also the decision in the C. Joyce on a similarly worded clause. The third argument, the second argument was one that succeeded, but there was a third fallback argument, also unsuccessful before the arbitrator and not pursued by way of respondent's notice on appeal, which was whether or not the cargo was legally dangerous. And again, the arbitrator answered that no. The fact that an ordinary commercial cargo may be damaged and may therefore lead to claims against the vessel does not make it legally dangerous. See the Daria Rad, which is the case about the fumigated rats and how many rats make a cargo dangerous or not, it may be. The particular dog that didn't bark or have occasion to bark was the vexed issue of the eternal bliss, another excellent decision of Sir Stephen's, although I understand that that may too be contentious. As many in this room will know, that is concerned with the exclusivity of demurrage, and in particular where there is a breach of the obligation to discharge within lay time leading to damage to a cargo, whether any such cargo liability can be passed down the chain as damages for breach of the obligation to discharge. That was not an argument that arose here because the damage was pre-shipment, but I mentioned that because in terms of the factual background, this is certainly not a million miles away from our facts, but with that key distinction. And I mentioned also just for those who are following the case, the Supreme Court hearing in that decision has now been fixed for the 19th and 20th of June of next year. So those are the arguments that were either unsuccessful or could not be taken before the arbitrator. I'm going to hand over to James now to explain the arguments that did go upstairs.
Thank you very much, Alex. Alex was too modest to say that he is counsel appearing in the eternal bliss. I should just make that clear. So we won in front of the arbitrator, and she issued a clearly reasoned and compelling arguments, some might think, why we should have won. But unfortunately, Alex got permission to appeal from Mr. Justice Popplewell, as he then was, and he was then successful in front of His Honour Judge Pelling QC. We then got a permission to appeal to the Court of Appeal, and we had a three-panel judge of Lord Justices Bean, Nails, and Rose. Now, Lady Justice Rose, as you'll know, is now in the Supreme Court as Lady Rose. Lord Justice Bean, as an aside, you may want to know, made an entertaining speech the other day to the Personal Injury Bars Association, which is available on the Judiciary website. And I'd commend it to you. But through the interest of this audience, he commented in relation to Lord Hobhouse that he was, and I quote directly, a desiccated calculating machine, unsuited to trying cases involving human beings. Now, members of the LSLC will know whatever his pros and cons might have been in trying personal injury cases, he was certainly very suited to shipping cases. And indeed, in 1976, when he'd been in sort for only 3 years, he appeared in 1 year as leading counsel in 7 cases in the House of Lords, of which he won 5. So, Alex, I think you'll be in sort of 3 years next year. You've got 1 case so far. You've got 6 to find before then. Now, Lord Justice Mail, Sir Stephen, of course, gave the judgment in the Court of Appeal and essentially agreed with his Honour Judge Pelling's decision. There were undoubtedly differences of emphasis, but I'm, for obvious reasons, going to concentrate on the decision of the Court of Appeal. See if I can get this to work. There we are. So the Court of Appeal held, by way of summary, but first of all, the words apparent good order and condition in a draft bill of lading are only an invitation to the master to make his own reasonable assessment of the state of the cargo. And they do not amount to a representation by shippers of those matters. Now just a word on nomenclature. Shippers and charterers are used slightly interchangeably in this case. And that is because in the usual way, charterers had a right to require bills of lading to be issued under the charter party, under the voyage charter. And again, as is not unusual, they made shippers their agents for drafting and presenting the bill of lading to the master to sign. So shippers, as a matter of fact, in this case, drafted the bill of lading and presented it as charterers' agents to the master for signature under the terms of the voyage charter. So that was point number 1. Point number 2, relying upon the decision of the Court of Appeal in the Nogger Marin, there is no necessity to imply an indemnity in these circumstances. And I'll come back to the Nogger Marin later. Thirdly, as properly construed, the description in the draft bill of lading wasn't inaccurate. And the analysis there is that you look at the words in apparent good order and condition and ask yourself, well, apparent to whom? And the one in the case of Peter de Grossa would say apparent to the master. And because the defects in the cargo were not apparent to the master, therefore there was no misrepresentation. Again, I'll come back to that in a moment. And then finally, Sir Stephen left open the question of what the result would have been had shippers, stroke charterers, actually known of a defect in the cargo. Because on the findings of the arbitrator, Sir Stephen found that was not actual knowledge, and indeed I accepted that. The findings of the arbitrator were that the shippers would have been able to discover the true condition of the beams, and she said, must be taken to have knowledge of the actual apparent condition of the beams. So if you like, it was a finding of imputed or constructive knowledge rather than a finding that any individual actually knew of the condition of the cargo. And Sir Stephen left for another case what would happen in circumstances where there was a representation which was false to the knowledge of the person making it. So we applied for permission to appeal to the Supreme Court in February 2021 on the following grounds. First of all, that the words used in the draft bill of lading were capable of amounting to a representation that they knew no reason why the master could not sign the bill in the terms presented. Secondly, that constructive or imputed knowledge was sufficient. And thirdly, third and fourth points are really taken together, that there should be no difference in principle between the law applying to implied indemnities in time and voyage charters and the Nogger Marin, albeit rightly decided, could be explained as a case on causation rather than whether there's an implied indemnity. 14 months later, we were sadly, from my personal perspective, turned down permission to appeal. Now, everyone here will know that asking a judge who's just made a finding against you for permission to appeal is quite a tricky piece of advocacy. Well, I can tell you that making comments about a judgment in front of the actual judge is even trickier.
Don't hold back.
And I'd just like to thank Alaka for giving me this opportunity for doing that. What I will seek to do is to explain what we would have argued in the Supreme Court, in case that's of interest, and perhaps seek to identify the areas of uncertainty that remain in the law, settled as it now is by the decision of the Court of Appeal and the Tai Prize on this particular point. So, the first point is, this is a case about a draft bill of lading. It's not a case about a bill of lading that was issued. Neither the decision of Judge Pelling nor Sir Stephen's judgments have been criticised in any way, so far as I can tell. But I might respectfully say that they've largely been read as essentially cases about bills of lading as issued and not about draft bills of lading. So, for example, Professor Tettenborn tweeted on the 28th of January 2021, in a bill of lading, apparent good order and condition means the carrier's eyes, not the perhaps better informed voyage charterers. Quite, full stop. Now, we're all accustomed to trenchant opinions, but that's, even in the context of the tweet, is a slight oversimplification of the issues that were arising. Everyone knows, and we did not dispute, that in a bill of lading as issued, apparent good order and condition means apparent to the master. And we've known that since the decision in Peta de Grossa, so for at least 100, not 150 years. And there are difficult issues when you have a bill of lading as issued about what might have been apparent to the master and the extent to which that raises the precise circumstances in which the cargo was loaded. Those are issues that arise on the bill of lading as issued. That was not our case. Our case was a dispute arising on a charter party about rights and liabilities that arise between the parties to the charter party, where the master is contractually obliged to issue a bill of lading in the form presented to him, unless he has good reason not to do so. So, if, as Alex accepted or Neil accepted, and as Lord Justice Mayles left open in the judgments, if there is a representation the shipper does not actually know of a defect, why is there not, for the same reasons, a representation that the goods are so far as the shipper ought reasonably to be aware, in good apparent order and condition. The shipper, when presenting the draft bill, is essentially asking the master to confirm its own assessment. And the master is obliged to issue the bill of lading unless he or she has good reason not to do so. And looking at it a different way, if the shipper or charterer is permitted to present a draft bill of lading describing the cargo in good apparent order and condition, even if it has reason to suspect that that is not the case, and present it to the draft bill of present it to the master on the basis that if signed by the master it would be true, then that is a recipe for encouraging shippers to conceal defects or deliberately not to take steps to inform themselves of the condition of the cargo. And it is in essence placing liabilities for defective cargoes, which should and could be identified by shippers before shipment. It's going to place the liabilities for those cargoes onto owners rather than the party who should be responsible for them, which is the shipper. The most recent supplemental edition of Scrutton has been updated, Chapter 6 in particular, to deal with the Tai Prize. And Chapter 6 is a chapter written by Mr. Justice Foxton. It couldn't be more authoritative. And the way that the supplemental has adapted paragraph 6.057 is of some interest. In this section, Scrutton is dealing with circumstances in which there will be an implied indemnity or an indemnity arising from mistakes in the bill of lading. And as you will see from the words I put up there, the words underlined are the words that have been added. The situation is now described as being ordinarily the case that when a draft bill is presented to the master, it's only a request to him to sign the bill of lading with such qualifications as he thinks appropriate, rather than requiring him to do that. Now, I wonder whether that distinction between being asked to do something with qualifications as might be appropriate and be required to do something, it is really a very firm distinction in the context of a bill of lading. Because we know from Mr. Justice Coleman's analysis in the David Agman-Ashebeli, and probably from our own practices, that what really happens is that the masters have to sign the bill of lading as presented unless they have good reason not to do so. And we all know that if the master does attempt to clause or condition a bill of lading in a way which doesn't reflect the agreed understanding of the facts, for example, in makes receipts or as identified by a surveyor or whatever it happens to be, then what happens then is there's an unholy row and everybody gets very upset and disputes arise. Because if a bill of lading is claused or is conditioned by a master, it causes all sorts of difficulties down the line, up the line, and to the vessel leaving the port. And the position from the David Agman-Ashebeli is that, in my submission, the master has to sign the bill of lading unless he has reason not to do so. So, for example, in the context of this case, the master would not, in any realistic circumstance, have been able to say on the bill of lading, good and apparent order and condition, but in reality, I couldn't really see anything of the cargo because there were such dust clouds raised in the loading of the soybeans that I was unable to express a view at all. No, the situation is that he was presented with a draft bill describing it at its in good apparent order and condition. And unless he personally could see and could justify some different description, then that's what he had to do. So, turning to the second point, the importance of actual as opposed to constructive or imputed knowledge in the usual way of these things really only arose in arguments in the court of appeal and hadn't been the focus of very much in the way of analysis or arguments up until that point. The judgment of Sir Stephen leaves for another occasion, what would happen where there is actual knowledge, which I understand to be a finding, in essence, of subjective knowledge, actual knowledge on the part of presumably an individual whose knowledge could then be attributed to the relevant party, whether that be shipper or charterer. And here we didn't have that finding. We just had a finding that on the facts, the shipper was to be taken to have known of the defect. The defect being that the soy being left out and was too wet. So the point we would have tried to argue in the Supreme Court was: is it right in this area of contractual law to get into distinctions between actual knowledge of that sort and findings of constructive or inferred or imputed knowledge? Is there a clear distinction between what is described as a finding of actual knowledge and what is in truth a finding inferred from the facts that somebody knew? And in the context of these sort of charter party disputes, is it realistic to think that anyone is ever going to be able to prove that an individual in Brazil or wherever it happens to be actually knew about that cargo? All you can ever really do is establish the facts as best you can and then make findings of fact by inference in relation to that. And again, from the David Agmash and Abely, in a slightly different context, but nevertheless, we would say analogous, Mr. Justice Coleman found that a shipper must be taken to have actual or imputed knowledge of the condition of the bill. That was in a different context because that's in the context where a shipper can make a claim. But nevertheless, we would have argued in the Supreme Court that the law in this area should be dealing with ordinary contractual findings of knowledge, i.e. imputed or constructive or by inference from available facts, rather than necessarily having to find actual knowledge. Point number 3 is perhaps the most interesting legal point, or at least to my mind. It wasn't open to us in the Court of Appeal. The Noga Marin, as everybody here will know, was a judgment of Lord Justice Mustle, where a dispute arose because the charterers had tendered a bill of lading, which the master signed, stating that a cargo of wire rods was shipped in apparent good order and condition. In fact, the cargo was rusty, and importantly, really importantly, the master was found to have been negligent in failing to identify that the cargo was rusty. So, important point of distinction between the Noga Marin and the Tai Prize. In the Tai Prize, there was nothing the master could have done to identify the defects in the cargo. The decision in that case, what was from Lord Justice Mustle, was that there would be no liability because an implied indemnity is unnecessary. I would have liked to argue before the Supreme Court that the law on implied indemnities in time and voyage charters could be brought into a happy state of consistency, but by construing the Noga Marin as turning on causation. Now, implied indemnities, at least in the context of time charters, are now usually looked at in the context of decision of Lord Justice Evans in the Island Archon, which says that owners are entitled to an indemnity from charterers against consequences of complying with orders, save in 2 circumstances. First, where the loss is one which the owners either expressly or impliedly have agreed to bear, or secondly, where there's a break in the chain of causation, i.e. the loss must effectively have been caused by the relevant breach. Now, if the Noga Marin is interpreted not as a case about whether there is an implied indemnity, but as a case where the claim for loss arising under the implied indemnity was broken by the negligence of the master, breaking the chain of causation, then you can bring it in line with the Island Archon. And you also bring in to consistency, voyage and time charters. As we all know, it's quite difficult, very difficult to bring a claim on an implied indemnity for voyage charters. But a sensible analysis, I would suggest, is that is because, generally speaking, owners in voyage charters are more likely to have accepted the particular risk. So in the voyage charter, it may be that the load port or the disport or the cargo has been identified, and so the owner has expressly agreed to bear the consequences of carrying out that voyage. In a time charter, charters have much more leeway about what they do. But if you interpret the same principles as applying to both time and voyage charters, and you interpret the Nogamarin as turning with one causation, then you have a happy consistency in the different areas of the law. Now, Alex will tell you, and it now appears from the judgment of Court Peely's rights that the judgment of the Tai Prize is entirely consistent with the textbooks as they existed before. I argue differently, and I tentatively raised for your consideration the way in which Mr. Justice Foxton's had to amend paragraph 6.058 of Strutton to support my analysis. That 6.058 sought to identify a general rule that where a master is not negligent, so we're still talking about the availability of an indemnity against mistakes, liabilities arising from mistakes and bills of lading. It says where the master is not negligent and the correctness of the bill of lading details are within the knowledge of the charterer or the shipper. The original text said, then the charterer will normally be liable to oblige to indemnify the ship owner against any resultant liability. The supplement now adds in that it will not arise where they are matters on which the master has an opportunity to form and is required to state his own view. Now, that is because the decision of the Court of Appeal in the Tai Prize says that the presentation of a draft bill of lading to the master, describing the goods as in good apparent order and condition, is and is only a request to the master to form a view about that. And it says nothing about what the shipper or the charterer understands about the goods. And therefore, the law has to be changed slightly to say, well, there may be an implied indemnity against the consequences of mistakes in the bill of lading, but that doesn't arise in relation to the condition of the cargo, because that is solely a matter for the master and the shipper has got nothing to do with it. Now, if that is the position of the law, then so be it. But it may be that some owners will find that a little bit difficult. And I would respectfully suggest the way in which the supplementals have to be amended does rather underline the previous clarity of what used to be paragraph 6.058. And we can see that in what is now paragraph 6.058A, because they've had to add a new couple of sentences. I'm not going to read out, but really, instead of being able to lay down a principle, that they are the editors simply describe the results of the Tai Prize and then say it's open for consideration what might happen if there's actual knowledge. So I would respectfully suggest that when the editors come to rewrite the book properly for the next edition, they might have to properly rewrite paragraph 6.058 rather than just trying to amend it like this. But maybe I'm wrong about that. So that is that was the point on the Nogamarin. And then finally, before I turn back to Alex to tell you why I'm wrong about all of this, I just want to try to summarize the points or the problems that it might be argued arise under the Court of Appeal decision. The first is that it's now unclear as to whether a representation ever arises when a draft bill of lading is tendered, because we have this lacuna about what happens if there's actual knowledge of a defect. So there's a lack of clarity there. Second is the point I've already made, but it is, I would suggest, really important that the consequence of the decision is that it may be in shippers' interests not to identify defects in cargo in the hope that the master won't identify them, and that they will therefore be correctly described as shipped in apparent good order and condition, even though the shipper knows, or even though the shipper should know, that they are not. And that has the consequence of meaning that the bill of lading is clean, and it will be difficult to make a claim on the bill of lading, depending on what jurisdiction you'll be in. But if there is a claim, the responsibility will probably rely on owners. And if it were the other way around, in line with the arbitrator's findings, then at the very least, there is a possibility that the claim could be passed down the chain back down to shippers, who are the party who are in fact responsible, who are in fact culpable for the original problem. If you just leave it with owners halfway up the halfway up the charter party line, then the party who's actually culpable for it gets away scot-free. The next point is the point I've already made. Is actual knowledge a realistic test to apply in these sorts of circumstances, particularly where you're in the middle of a chain of charter parties, you have no access to the relevant individuals, and it's very difficult to take evidence, to find evidence about what actually happens. Now, it may be said against me that practicalities of those sorts shouldn't drive the law, and obviously that's the point of some courts, but nevertheless, if actual knowledge is the test, then it does rather undermine the ability ever to pass these liabilities on. Penultimate point, I'd suggest it goes against statements in established textbooks. Alex can say that no one's jumped up and danced about it so far, so I don't know how far I can take that point. And then finally, judges often talk about the need of the common law to balance clarity and justice, and certainly the Tai Prize bring clarity to the law. But I respectfully wonder whether it in fact did justice on the facts of this case.
Well, that's a fine crescendo on which to finish. Alex, over to you.
James. Wish you better luck with the slides.
Thank you. Working at all now.
It's so easy.
Thank you very much, James, for outlining what would have been said. And in a way, I have equal, if not greater, trepidation seeking to defend the judgment, because the temptation is just to endorse it, to say read it, and that I have nothing to add. Since we are here, since James has sought to outline some further and additional points that might have been developed had we got to the Supreme Court, I will do my best to address them. So I start where the judgment starts, which is really to hone back in on this question of the meaning of apparent good order and condition, because James's case was built upon the foundation that the bill of lading was inaccurate, and it was on the basis of that alleged inaccuracy that he successfully persuaded the arbitrator that there was some implied indemnity or warranty against the consequences of that inaccuracy. In fact, as Judge Pelling QC and the Court of Appeal rightly held, apparent good order and condition means to the master, and there is a long line of authority that supports that. The starting point, as James has fairly recognised, is that the words in a shipped bill represent the assessment of the master. And although the master has to perform his duties consistent with a reasonably observant master, it is the assessment in the conditions in which loading took place. So whilst there are, in fact, a quadrilogy of cases that we cited, Silver and Ocean Steamship is perhaps an interesting one. That was a case in which a cargo of frozen eggs was loaded under floodlights, and so in poor visibility conditions. And in assessing what was apparent to the master, the Court of Appeal in that case had regard to the conditions in which the cargo was loaded. So the subjective assessment of the master as regards the conditions is part and parcel of the words apparent good order and condition in a shipped bill. The second point is that it cannot realistically be said that every statement in a draft bill is a representation made by the shipper. And I give the obvious example of quantity unknown. That is a matter which is adopted in the mouth of the master, but is clearly not a representation by the shipper. And to the contrary, the shipper will go on to warrant any particulars given as to weight and so on. So the commercial oddity of the owner's case is that even in circumstances where not everything said in the draft bill is a representation or could sensibly be a representation by the shipper, nonetheless, the same words, apparent good order and condition, in the shipped and the draft bill are to be regarded as somehow different. And he needs that to introduce that difference in order to set up the argument that the draft bill is inaccurate, even if the shipped bill, using the same words and on the same facts, is accurate. And we said that that was a curiosity in his case. Further difficulty that owners had is Article 3, Rule 3 of the Hague Rules, which distinguishes between information provided by or on behalf of and warranted by the shipper and apparent good order and condition. And the structure of Article 3, Rule 3 is that it has three sub-rules, A, B, and C. A and B relating to leading marks, B relating to numbers of packages, pieces, quantity, or weight, as the case may be. Both of those are particulars to be inserted into the bill as furnished by the shipper, and which are then expressly warranted under Article 3, Rule 5. The way that the Hague Rules are drafted, however, is that no equivalent wording of furnishment by the shipper appears in the context of apparent order and condition, and nor is there any express warranty in relation to apparent order and condition for what we would say is the obvious reason, that is because it is assessment by the master rather than anything that has been furnished by the shipper based on its own knowledge. So given that that is the express regime set out in the Hague Rules, the owners had a difficult task in persuading, well, apart from before the arbitrator, but certainly when we got to the Judge Pelling in the Court of Appeal, have a difficult task in explaining why there should be an implied indemnity or warranty. And the starting point, of course, as with any implied term, is that save for those terms that are to be applied as a matter of law, as with any implied term, the owners would have to show that it was necessary for such an implication to be made. In the context of a time charter, such an implication has been held since the Island Archon to be necessary as, in effect, the quid pro quo for the owners allowing charterers great latitude in terms of the voyage orders that can be given. And as James points out, that is why there is some debate as to whether or not an implied indemnity can be arise in a trip charter. But what is clear authority and has been since the decision in the George C. Lemos is that the scope of an implied indemnity is narrower in a voyage charter, certainly than in a period time charter. And that distinction is not only well established in law, but right in principle, given that the basis upon which the implication is made in a time charter is because of the much wider range of employment orders that can be given. And indeed, in that regard, it is perhaps significant that the arbitrator also rejected owners' claim that they could recover under what one might call the general implied indemnity. James has touched upon the fact that the point was not open to him come to the Court of Appeal. That's because he lost on it before the arbitrator and rightly decided not to pursue it by way of respondent's notice on appeal. So it was a point that was not open to him, but even if it had been open, would have been a bad one. some reliance was placed upon the more narrowly formulated implied indemnity, which he has addressed you on, and a series of other authorities. Those are discussed, as I say, at paragraph 70 to 74 of the judgment of the Court of Appeal. They are either not concerned with apparent ordinary condition at all, e.g. Dawson and Adler, which was concerned with weight, or to the extent that they are concerned with the condition, they arise in a very different context, such as Groves and Webb, which was a case involving warehousing. So drawing those particular threads together, we said and succeeded on the argument that the implication of an indemnity and warranty was particularly difficult given Article 3, Rule 5 of the Hague Rules. That was a point that was dealt with at greater length by Judge Pelling at paragraphs 29 and following of his judgment, which, as we know, was upheld. So in default of those conceptual legal points, James's fallback was to pray and aid almost in terror, this idea that all of the shippers would go around committing frauds and there would be an encouragement to misdescribe. Whilst I perhaps present a bit of a pastiche of his argument, the arbitrator at least seems to have been influenced by what, in fairness, is a hard commercial decision and the perceived harshness on the result on a disponent owner who did have to make a substantial contribution towards the hen owner's claim in circumstances where neither the disponent or indeed the head owner could be said to have been at fault. But the reality, as we all know, is that that is one of the risks that parties undertake, where they charter in and charter out on different terms. And indeed, the George C. Lemos is a good example of the risks of being caught in the middle. James's clients were only liable for 50%, and they were only liable for that 50% because the time charter incorporated the ICA. If they wanted an indemnity in equivalent format, they could have sought to incorporate the ICA or to have provided for an express indemnity along the lines that James suggests. And although I would be interested in the experience of others, since the Tai Prize, oddly enough, the charter wasn't up after the Tai Prize was decided, so I can't pretend that it was redrafted because of the decision. But I have certainly seen a charter since that did have an express indemnity that would have responded in these circumstances. So it is certainly not beyond parties, even in a voyage charter, to incorporate that sort of express indemnity. And then so far as the distinction between actual and constructive knowledge, that is, of course, a distinction well known to the law, particularly in the field of misrepresentation. What James seeks to suggest is that there should be an implied absolute warranty to combat effectively dishonesty, and that there is no conceptual warrant for that. The fact that that fraud and dishonesty claims may be hard to prove is no reason to adopt an unprincipled approach to implied terms. Coming then on to the Noga Marin, I respectfully echo what was said, that this case is fatal to the case that was put forward by owners. And it is important, particularly given James's argument this evening, that at least in the Court of Appeal, the Noga Marin was not only determined on causation grounds. So before it was another appeal on a point of law that came initially through the arbitrators and then up to Mr. Justice Staunton, as he then was, and then to the Court of Appeal. Before the arbitrators and Mr. Justice Staunton, there was a concession that there was an implied term or indemnity, but the argument was focused on the causation argument. In circumstances where the master was negligent, the argument that prevailed before both the arbitrators and the judge was that that broke the chain of causation. In the Court of Appeal, however, that concession was questioned on the wider basis as to whether or not there could be an indemnity implied at all. And I've set out on the slide part of the judgment of Lord Justice Muskell. He said at page 422 of the Note of Marin, everyone in the shipping trade knows that the master need not sign a clean bill just because one is tendered. Everyone knows that it is the master's task to verify the condition of the goods before he signs. This being so, we cannot understand the request implicit in the tender as being more than this. The charter requires you to bind your owners to a contract containing the bill of lading, and please do so. The bill of lading also constitutes a receipt, and please sign it as such, with whatever appropriate qualification you see fit. If this is the right account of the transaction, as we believe it to be, the claim for an indemnity must fail. So that is clearly different to the cases going back to Sheffield Corporation and Berkeley, or even the voyage orders in a time charter. What is being presented to the master is a bill upon which he can carry out his own assessment. The result of that assessment is then what is presented to any subsequent holder of that bill, and he is only stopped from challenging apparent good condition to the extent that it was apparent to the master. So this is a rather different case to those outlined by James. Finally, to round off the further alleged problems, I've touched upon the so-called encouragement to misdescribe. There is the interesting question, which is left open for another day, as to whether or not there is an implied representation of no actual knowledge of defects, but whether or not that is a suggestion that bears fruit in the fullness of time. The reality is that, first of all, the shippers run the risk of a claim under the sale contract by the receivers receiving damaged goods. Secondly, that there is no evidence of a spate of shippers engaging in a concerted campaign of misdescription. And thirdly, as I have indicated, he is always open to the parties to incorporate express indemnities or other terms such as the ICA. The second point is that there has been no criticism of either the decisions of Judge Pelling or the Court of Appeal in any of the most recent texts that have commented upon this. I think James suggested that Scrutton had to be updated slightly, but again, there is no hint of criticism in those updatings. So it is, I would suggest, simply routinely updating texts following important decisions, as one often sees. And interestingly, Voyage, the most recent edition of Voyage Charters, which was only published, I think, at the end of August. So there was a passage in the previous edition, which James had prayed in aid and said supported his case. But even Voyage Charters refers to the Tai Prize without any hint of criticism. And I have a reference to Hepburn and Walpole article, which is also referred to in Scrutton, where it describes the decision of the Court of Appeal as consistent with orthodoxy. So all of the texts seem to be happy with the decision, and certainly within the legal fraternity, I'm not aware of any criticism. I again be interested to see what the commercial reaction would be, but as a matter of law, there is no suggestion that the case was incorrect. So I round off, if I may. I think with something that perhaps everyone on this panel would recognise, that this was a hard case on the facts, certainly so far as the disponent owners were concerned, but it was legally correct, and it is simply the outcome of a contractual allocation of responsibility that commercial parties entered into, but as often is the way, regretted when it came to it.
Well, thank you both very much for a very thorough exposition of the issues in the case and the problems to which it may give rise. Perhaps I could just add two comments of my own. First, we all know that Scrutton is a sacred text, and I'm sure that the editors would have no qualms about saying that a decision was badly decided, if that's what they thought. So I'm very pleased to have escaped with merely a bit of tinkering to the text here and there to take account of this decision, and we'll wait with bated breath to see what the next edition, when it's fully rewritten, may bring. I haven't seen the latest edition of voyage charters, but coming as I do from 20 Essex, I'm particularly sensitive to any criticism there. So I'm pleased to hear from Alex that they seem to be able to live with the decision of the Court of Appeal. Second comment, again, I'd be interested to see what people think. James concluded by saying that the decision of the Court of Appeal had achieved clarity at the expense of justice. Well, I know what he meant, but another view might be that if you give clarity or certainty, then you do achieve justice. And that if parties don't like the result, at least they know where they stand and they can do something about it by drafting an appropriate clause, either for individual charters or possibly something which might be looked at on an industry basis if this is thought to be a common problem. I suppose there are a number of possibilities. One view would be to leave things as they are and let the loss lie where it falls on the owner, taking the view, well, that's what P&I companies for. I hope there aren't too many club people in the room or watching who would take too much offence at that. Another possibility, and Alex said that he had seen this, is to draft some form of express indemnity. Obviously, that would require some careful drafting, and I wouldn't begin to try my hand at that off the cuff, but no doubt that could be done. That might even be susceptible to further litigation to see if it achieved its purpose. Who knows? Or a third possibility, which Alex also mentioned, lies in the interclub agreement. In fact, the facts in the Tai Prize were that the head charter was subject to the interclub agreement. So the original liability of the owners, which I think was $1 million or thereabouts, was split 50-50 under the head charter because the interclub agreement applied to that. And it was the charterers, the disponent owners, portion of that, which was then sought to be passed down. Well, I suppose you could either in an individual charter or perhaps by amending the interclub agreement, have a provision that in the event that the damage was caused by the condition of the cargo on shipment, then loss would be 100% to the charterers. I haven't thought that through, but that seems to me to be a possibility which would solve the problem, would give the justice which James is seeking, and would be equally uncertain. But I'm equally certain, sorry. but as a slip of the tongue. But others in the room or elsewhere will need to think a lot harder about that to see if it works before they do. And I don't make any warranty about that. Now, have we got any questions or any comments that people would like to make based on either anything to do with the case or... Yes, Graham, your hand went on first. Sorry, can I just ask people to... Everyone knows Graham. Can I ask people to identify themselves so that those listening know who's speaking?
Graham Harris. I've had a number of these cases going back many years. In fact, it's unusual to have a court case as identical facts.
It's unusual.
Advised on years and years earlier.
It's unusual for you to have court cases anyway. You settle all your cases.
But one point occurred to me. I'm not a cargo expert, cargo insurance expert in this context. Oddly enough, I've only ever advised in the same time in this scenario. Because it's pre-shipment damage, would a different decision to the Court of Appeal's decision simply have passed an insured loss onto a party who's not insured?
James, you're the one who wants to pass it on.
Well, I think I'm not aware of the instance of insurance in this case, but in terms of insurance against actual liabilities. So I'm not able to answer that, I don't think. Alex, maybe.
I'm not sure whether we had charterers liability cover, actually. I mean, we definitely had FDD.
Would you expect the time charter, the owner of the time charter?
The voyage charter, maybe not.
Well, I think the voyage charter is sort of traditional, sort of trading side. You know, if it is a trader who's the voyage charterer, he's probably got a master policy. Yeah. But it's still a cargo policy, not a P&I policy.
I suppose one benefit of being able to pass a claim down the line is that eventually you get to the person who actually has a contract with the shipper whose fault it all is.
Good advice in the sense your decision complies with market expectation. It's the insurance structure.
Well, good. There's a hand at the back.
So
Yeah.
Smooth from a commercial point. When you talk about Nogger Marine, the loading cargo seals must quite traditionally have a preloading inspection. Sometimes they find a soybean, which is loaded a silo, which is also a big container shoe into a ship. It's loaded about 10,000 tons a day. So it's in practice, it's very difficult for the master. It's the master inspect something that's flying down the chute at 10,000 tons. You know, it's an impossibility. So it just seems a bit unfair to be put responsibility on someone that basically signing an agreement to carry a cargo. I mean, it just seems a bit like having a game show. So the prizes are going past in the Nogger at speed, but this tiding they're going past them faster, but not remembering what's on the conveyor belt. So it just seems a bit harsh.
Well, I agree with that. And obviously one of the key points of distinction that could be made and was made between the Tai Prize and the Nogger Marine was that in the Nogger Marine there was negligence on the part of the master, whereas in the Tai Prize there's no criticism of the master personally. I think the slight oddity in a way is that certainly on the facts as found by the arbitrator, there should have been no cargo liability to the head owners. The cargo claim ought to have failed. Now, it's impossible to speculate why the Chinese courts decided it in the way that they did. But then the question is, if you have a liability that shouldn't have arisen, where should that sit? And can you effectively devise a series of implied terms in order to pass that down, or subject to any particular express terms, do the losses fall where they lie? And I think the answer that has been given is that they fall where they lie.
Yes. Yes, go ahead.
Peter from LMAA from Vancouver.
Yes. Well, welcome.
Is the possibility? Could there be a possibility that goods were damaged transit due to the sea? You pass down the balance to the cargo and prices. It's transit from Sapporo to a voyage. It's a long voyage. See, the goods could be damaged. Transit.
Well, it was the receiver's case in China, if I remember rightly. I'll be corrected if I've got this wrong, that the damage was caused during the voyage by heat from the vessel's fuel tanks adjacent to the cargo holds. And it may be, we don't know, that was the finding of fact which the Chinese court made, in which case the ship was responsible and the problem goes away. But the arbitrator found that it was pre-shipment damage. So so from the point of view of the appeal to the court and the question of law, those were the facts on which we had to work.
And indeed, there was a dispute in the arbitration about the reason for the damage. And Alex argued, albeit not particularly strenuously, that it might have been caused by something on the ship.
Yes. The hearing was on submissions alone, but there were surveyors and expert reports put before the arbitrator and submissions made on those. And certainly our factual case, although it's fair to say we felt stronger in the law than the facts, as ultimately vindicated. But our factual case was that the cargo damage was through heat coming up from the vessel's tanks.
But you raise, if I may say so, an important point, because there is always the possibility that the local court at the discharge port will take a different view of the cause of the damage from that which may be taken by an arbitrator in London. So that's just a different factual finding, probably on different evidence. There'd be surveyors called in the Chinese court or wherever the discharge port is, and they'd say what they thought the cause of the damage was, and the Chinese court would take a view about it, but the London arbitrator, dealing with a dispute under the charge party, is not bound by that and may take a different view. And that may be what happened in this case. I don't know. Aleka, did you have a question?
Yeah, for our international audience, with voice, I need a microphone.
Come and speak.
Not an amplifying one, I'm afraid.
I'm fine.
It's not an amplifying.
Okay. I think this is a wonderful panel. It will not happen anywhere in the world to have two opposing lawyers with the judge of the case and argue in a civilized manner and not fighting. So intellectual, such an intellectual debate. People bear this in mind. This is happening in the UK. And I'm grateful to all of you for coming along. And I'm grateful to our judge who did not take any offense. And he doesn't take any offense with me now, what I'm going to say.
Well, that was a big build-up, wasn't it?
I'm inclined, not because I taught the subject about 16 years of UCL, but I think the principle is correct. We all know that apparent good order and condition is what the master sees, and the duty of the master to sign and confirm the apparent good order and condition. And if he's negligent, like the Noga Marine, that is a matter of causation, and the owner is liable. But in this case, I'm puzzled because the facts were there was pre-shipment damage. Wasn't that pre-shipment damage the wet, you say, James? Was not apparent to the master, or did you have to dig down to see? Apparent is what he sees visually on the top. Was the wetness apparent on the top?
No. So the findings of the tribunal, based upon the expert evidence, is that the damaged soybeans were within the body of the cargo underneath.
Yeah, nice.
Yeah. Well, yeah, quite. So this comes back to the point that's.
Yeah, the judgment as such is correct. That's nice. The principle is correct. What happens there is a matter of evidence, examination of the facts. So, if it was found, it was wet, pre-shipment, there should be implied indemnity. As James says, and I agree with that, there should be implied indemnity in both time and voyage, although there are differences in the orders. But unfortunately, we may have another case to go to the Supreme Court. Thank you very much indeed.
Well, you can leave off next. Yes.
Okay. I'd like to ask Alex in particular whether it would make any difference to the law if, as one very often sees, there's a clause in the voyage charter party obliging the master to sign the bills to leave, which may also say it's his duty to reject any couples which he would clause the bills. We keep on finding new terms that are implied by law. And wouldn't it be plausible that when there's that, the situation is different as a matter of law from the Noga matter? It's not realistic to say it's an invitation to the master to express his opinion. He's bound by the charter to sign the leave.
That's an interesting question. I suppose on different facts, the first point is that any obligation to sign clean, if the master was in fact aware of defects to his knowledge, the question would then be whether he was obliged to sign, notwithstanding, because that would then be a fraud on the receivers of the subsequent holder. As to whether or not on our facts it would make a difference, I suspect not, on the basis that it wouldn't be sufficiently different to as presented. Clean in those contexts would still be construed as clean to his reasonable assessment, because that is how clean would be understood in the trade, would be my submission. But it's an interesting question. If there is such a case, it will be interesting to see whether the Tai Prize is distinguished. I would suggest not, but I can see the argument both ways.
Now, do we have time for another question if there is one, or we draw into a close? Yes, any more? Or perhaps I So I stop people by saying that. Right. All right. Well, if we don't have any more questions or contributions that people would like to make, then thank you very much to everybody who did ask a question and the stimulating discussion we've had.